Hello and welcome to Mayer Brown's Global Receivables and Supply Chain Finance webinar, the 10 most common insolvency questions in receivables and payables finance, with a focus on Asia and Europe. My name is Ben Sandstad and I'm a partner in Mayer Brown's Hong Kong and Singapore offices and co-leader of the firm's Asia Supply Chain Finance practice. Joining me today as co-presenters from Asia, firstly Angelia Chia, a partner in our Singapore office and co-leader of our Asia Supply Chain Finance practice with me, and John Marsden, a partner in our Hong Kong office and firm practice leader for our Asia Restructuring and Insolvency practice. From London, Sheena Frazer is counsel in our restructuring practice, and Ravi Amin is a senior associate in our banking and finance practice. Before we begin, a few housekeeping announcements. Firstly, at the bottom of your screen, you will notice that there are several application widgets. Answers to some common technical issues are located in the Help widget. Secondly, this webinar is being recorded. In a day or so, we will be sending you an email with a link which you can use to listen to the webinar again or share with your colleagues. Finally, we plan to allow time during the program for questions. To submit a question electronically, please use the Q&A widget. If we don't get to your question during this webinar, we will make every attempt to follow up with you afterwards. A bit of background. Who are we? Our Global Receivables and Supply Chain Finance team is a large global team specializing in supply chain finance, trade finance, asset-based lending, and trade receivables securitizations. And we advise many of the world's leading participants in this market. For several years, we have hosted a series of live client events covering supply chain and working capital finance in London, New York, Hong Kong, and Singapore. In 2019, over 600 guests attended these programs. Unfortunately, we have had to postpone these industry summits this year, but we hope that we will be able to recommence these in 2021. In the meantime, we are hosting a series of 9 webinars, which we hope you will find useful. This is the second webinar in our series, which commenced with the companion presentation last week, which focused on US insolvency questions. Given the current economic situation, we have been fielding a lot of questions from clients lately in relation to insolvency, and we thought this would be a good place to start the series. The next webinar, on the 5th of August, will focus on capital markets and alternative investors investing in trade finance assets. Your invitations for this webinar have the complete list of upcoming webinars, which are hosted twice on the relevant day to accommodate different time zones. On a related note, our Global Receivables and Supply Chain Finance team forms part of an industry group advising on supply chain and distribution, with a focus on contracting, compliance, and disputes across the globe. It may be of interest that we are also running a series of webinars covering a range of topics such as contract risk, reshoring, and reputational risk. Further details are on the slide 4. Lastly, before we turn to the 10 key issues, let us contextualize references to parties in a supply chain finance transaction. Slide 5 sets out 2 diagrams from the standard definitions for techniques of supply chain finance, published by the Global Supply Chain Finance Forum, which is essentially a group of the key industry bodies in this space. On the left-hand side is the standard structure for payables finance, sometimes also referred to as buyer-led supply chain finance, as the key relationship for the finance provider is with the buyer. On the right is the standard structure for receivables discounting or factoring, sometimes referred to as seller-led supply chain finance, as the key relationship for the finance provider is with the seller. As these standard payables and receivables structures should be familiar to all of you, and we have covered these in previous years, I will not run through them. However, for context, during this presentation, when we refer to the insolvency of a company, it could be any of the buyer, the seller, or the finance provider, whether in a payables or a receivables program. Although, please note, we will not go into the specifics of insolvency in respect of a regulated institution. And obligor, if we refer to it, is referring to the buyer in respect of its payment obligations under a receivable. So let's now turn to the 10 most common insolvency questions in receivables and payables finance, and we will start by covering Asia, with a focus on Hong Kong and Singapore. Angelia Chia, as a Singapore qualified lawyer, and myself, as a Hong Kong qualified lawyer, will talk to each question, and John Marsden will provide observations and commentary. One caveat. Last week, the Singapore Ministry of Law announced that the Singapore Insolvency, Restructuring and Dissolution Act will commence this week on the 30th of July. This means there is now omnibus legislation in Singapore, which consolidates individual and corporate insolvency and debt restructuring laws into a single piece of legislation. And it also aligns much of Singapore's insolvency laws to international best practice. We have done our best to update our presentation over the weekend. However, we may only cover certain Singapore insolvency concepts at a necessarily high level. So, question 1. Does a company need to be insolvent to file for insolvency? And the answer is no, but it depends on who is instigating the procedure. At the outset, let's talk to what does it mean to file for insolvency. And this question is really driven by our US friends and the US concept that a US company can file for bankruptcy and obtain the benefits of Chapter 11 under the US Bankruptcy Code, namely an automatic stay from creditor actions and certain other benefits, such as the ability to obtain debtor in possession financing and to have free and clear sales of assets. However, in Hong Kong, there is no such equivalent of Chapter 11, so it is somewhat incongruous to refer to filing for insolvency in this context. Instead, we use the concepts of liquidation and winding up, which are broadly interchangeable and refer to realizing a company's assets, distributing the proceeds, and bringing the company to an end. Liquidation or winding up is either voluntary in that they involve the discretion or agreement of the company, its members, or its creditors, or involuntary in that it is mandatory by order of the court, which we'll cover in the second question. For Hong Kong, the voluntary insolvency procedures are listed on the left of this slide, and they include, firstly, members may resolve to liquidate a solvent company. Creditors may resolve to liquidate an insolvent company. And thirdly, under a special procedure, directors can resolve to liquidate an insolvent company where winding up under another procedure is impracticable. Lastly, please note that Hong Kong also recognizes schemes of arrangement. However, these apply to both solvent and insolvent companies and essentially permit the company, its shareholders or creditors to at any time attempt to reach an agreement which, with the sanction of the court, will bind the company, the shareholders, or the creditors as applicable. So that's Hong Kong. Let's welcome Angie to talk to Singapore.
Thank you, Ben. As Ben mentioned, Singapore's Insolvency, Restructuring and Dissolution Act of 2018 comes into effect on the 30th of July 2020. Like Hong Kong, Singapore uses the terminology winding up, and the concepts used in the new act are broadly similar to that in Hong Kong, in that winding up of a company can be voluntary or by court. In respect of the response to question 1, one key difference between Singapore and Hong Kong is that in Singapore, many of the effects of a winding up can also apply in what is particular to Singapore, judicial management. A company can be placed in judicial management if it is likely to be unable to pay its debts, but there is a chance of rehabilitating the company. Back to you, Ben.
Thanks, Angie. So question 2, what then is the position for involuntary insolvency? Well, generally, yes, a company must be insolvent for involuntary procedures to apply. As mentioned, involuntary insolvency procedures are mandatory by order of a court. For Hong Kong, compulsory liquidation occurs when a winding up petition is filed by the company itself or by its creditors, and the court issues a winding up order. Now, the court will only issue a winding up order in certain circumstances, some of which do not require insolvency. However, the most common is when a company is unable to pay its debts. If the court makes a winding up order, a liquidator will be appointed. And please note that after the presentation of a winding up petition and prior to the making of a winding up order, the court may appoint a provisional liquidator to preserve the assets of the company. So that's Hong Kong. Again, Angie, please talk to Singapore.
Thanks, Ben. In this respect, Singapore is similar to Hong Kong, save that our threshold amounts are different. Whilst in Hong Kong, it's Hong Kong 10,000. In Singapore, it's Singapore dollars 15,000. That is almost 10 times more depending on the exchange rate. Back to you, Ben.
Thanks, Angie. Question 3. Many of our clients say, well, that's great. How will I know? Will I know immediately if a company files for insolvency? And the answer is, well, actually, no, you won't know immediately, but it is certainly possible to find out. And in this regard, the availability of information and the location of that information depends upon the specific insolvency process. For example, in Hong Kong, each of members' voluntary liquidation, creditors' voluntary liquidation, and the special procedures for directors to voluntarily liquidate a company have different publicity requirements. However, in summary, you would typically search the Hong Kong Companies Register as well as the cause book of the High Court of Hong Kong. And these are searches that we conduct at your request and always when we are conducting and issuing capacity opinions in respect of the Hong Kong company. It's also possible to search the Official Receiver's Office as well as the Hong Kong Government Gazette, as well as monitoring Hong Kong newspapers. How about Singapore, Angie?
Thanks, Ben. Well, this is where we see some differences between Singapore and Hong Kong. In Singapore, all resolutions passed by a company in relation to a winding up will have to be filed with the Accounting and Corporate Regulatory Authority, or what we call ACRA, including where there is a member's voluntary winding up. Additionally, for judicial management, which is unique to Singapore, there will be clear indication of judicial management as under the legislation in Singapore, every invoice, order for goods, business letter, and every internet website must indicate that the affairs, business, and property of the company are being managed by a judicial manager. So it would be hard to miss that. Back to you, Ben.
Thanks, Angie. So the next question, question 4. What is the effect when a company files for insolvency, and why should I care about it? Well, broadly, there are 3 key effects. In Hong Kong, firstly, for all voluntary and involuntary or compulsory liquidations, powers of the directors of the company cease following the appointment of a liquidator. Secondly, for compulsory liquidations, after presentation of the winding up petition, any disposition of the company's property is void unless the court orders otherwise. Additionally, after a winding up order, any action or proceeding against the company or its assets or property is frozen, except with the leave of the court. Please note that this automatic stay does not extend to actions by secured creditors to enforce their security. Thirdly, certain existing transactions and certain future transactions may be subject to insolvency unwind. That is, they may become vulnerable to be unwound in certain circumstances, and we will cover this later in the presentation. Now that's the Hong Kong position. Angie, how about Singapore?
Well, the position in Singapore is broadly similar to Hong Kong. And the only thing we'll have to bear in mind in Singapore is that companies under judicial management will also have the same protections from proceedings. That's it then.
Okay, thanks, Angie. So question number 5, and it's normally in these terms. Okay, I bought receivables, I bought them in a true sale. Can my purchase be challenged on the insolvency of the seller? And the answer to that is generally insolvency will not impede the true sale of receivables. Subject, of course, to possible insolvency unwinds, but in practice, we should note that insolvency is the time when the nature of transactions, in this context whether they are actually a sale versus secured lending, is typically challenged. So firstly, insolvency unwinds. We've just mentioned that For compulsory insolvency procedures, these may trigger the ability to petition for a transaction to be unwound by the court. We'll cover those later, so let's move to true sale. And what is true sale? It's an important question to ask because in Asia it really is a complicated beast, and there is lots of confusion over what it exactly means. It is not a legal term of art in Hong Kong, and it is also confused with US concepts such as true participation, as well as accounting-driven concepts of derecognition and off-balance sheet financing. In Hong Kong, when we talk about true sale, we really have to deal with two broad concepts. And the first is, have we got some form of sale or transfer or isolation of the beneficial interest in assets, which is sufficient to ensure that beneficial interest will not form part of the insolvency estate of the seller. And if you do not have such a transaction, then true sale is irrelevant. Secondly, assuming that you do have such a sale, transfer, or isolation, has this been done in a manner which minimizes recharacterization risk? That is, the risk that a court may be asked to construe the true nature of a transaction in a manner different from that expected. For recharacterization risk, in this context, there are two key consequences. Firstly, if a sale is recharacterized as a secured loan, it may be void against the liquidator if it has not been duly registered. Now, in this regard, in Hong Kong, there is no registration regime for sales of receivables, and it is also not market practice to include a backup security interest in true sale structures. So what this means is if it is recharacterized as a secured loan and it has not been registered as a security interest, then the finance provider will rank as an unsecured creditor for the amount of the purchase price. Secondly, where the financier is not a regulated institution or regulated moneylender, the fact that the transaction is considered lending as opposed to a sale may trigger unlicensed money lending concerns. And we have seen cases in Hong Kong where the authorities have pursued such actions. However, we have very facilitative case law on point, and when we issue true sale opinions, we issue them regularly and they are not contested. We also advise on a range of true sale transactions in Hong Kong, including in the context of participations and transfers of non-assignable assets. So that's Hong Kong. How about Singapore, Angie?
Ben, I loved your description of true sale in Asia being a complicated beast. And you were just describing that in the context of a transaction governed by Hong Kong law. There are many times when the transactions are governed by or impacted by laws other than the laws of incorporation of the seller. Say, a Singapore seller selling in receivables under a receivables purchase agreement governed by New York law. And the seller is wound up under Singapore laws. Which laws apply, and what is the impact of that? Now that brings complication to the next level. But as we have more and more of such multi-jurisdictional deals, we do have to address these issues clearly so that parties achieve what they had intended to when they entered into the agreement. In terms of case law, as these products grow in awareness and utilization, Singapore too has a few well-reasoned decisions which should give participants comfort as to the parameters that the court will apply in determining if a true sale has been achieved. So, that's the first 5 most common questions in respect of insolvency and receivables and payable structures. To provide commentary and reflections on Asian insolvency, John Marsden will speak to the next slide.
Thanks, Ben and Angie, very much for those kick-off comments. And it really brought into focus a number of issues that are relevant to what we're talking about today. Insolvency per se. What is insolvency? It's either a cash flow test or a balance sheet test. Taking the balance sheet perspective, we know receivables, if a true sale has happened, they shouldn't be on the balance sheet. So they're not going to be part of the company's assets. Which brings me to the first thought that a liquidator will have as soon as he gets appointed or she gets appointed, and that will be, I'm going to take control of the company's property, and in so doing, I'm going to look at those receivable purchase agreements. I'm going to look at them because there are very few sources of assets many times in the liquidation of companies that are readily available. The two that spring pretty quickly to my mind are accounts, and they may be designated accounts like receivable purchase accounts, and they may be the receivables themselves that are out there waiting to get paid. As mentioned by you, and quite correctly, if I bought the receivables in a true sale, then they are not property of the company. They can't fall under the control of the liquidation because the liquidator can only take control of property of the company. Anything else, he or she will hold the property on trust for the beneficial owner. That throws up the first two risks. You've said it, Ben, you've said it, Angie, recharacterization risk. Are the assets really those of the purchaser, or are they properly characterized as a secured lending and subject to avoidance because of want of registration? Secondly, a conveyance of property after the commencement of the winding up is void, subject to approval of the court subsequently. Now, we know that in normal debt purchase arrangements, we have phrases like all debts existing on the commencement date or arising after the commencement date during the term of this agreement on and subject to the terms of this agreement. In other words, debts will be purchased not only existing at the time of the debt purchase agreement being entered into, but subsequently. Now, the subsequently raises an interesting point because in a creditor's involuntary winding up, that is an insolvent winding up, generally governed by the court, the winding up occurs when the filing is made if the company subsequently goes into liquidation. However, during that intervening period, people may be trading those debts, you may be buying those debts, you may have assumed that those debts are coming to you and that they're the property of the receivable purchaser. That is subject, of course, to that provision voiding dispositions of property after the commencement of the winding up. It goes to interesting questions about did you properly purchase the asset? Was it paid at proper value for the asset? Was the discount too great to make it a void transaction in reality? And such questions are too difficult and in-depth to get into in this conversation at the moment, but it throws up a plethora of issues for us.
Thanks very much, John. It's great to get your insight into such matters. So turning back to the questions. Question 6, can I enforce outstanding receivables and collect against the obligor directly so that proceeds of the receivables do not go into the seller's collections accounts? And broadly, the answer is yes. In Hong Kong, the key concern from an insolvency perspective is whether the automatic stay in the context of compulsory insolvency procedures, which prohibits legal proceedings against assets of the seller, applies. And John touched on this in his commentary. In short, provided the sale of receivables from the seller to the finance provider is a true sale, then the receivables will not be assets of the seller. So notwithstanding the insolvency of the seller, the finance provider may deal with those assets as the proprietary owner. And that includes the ability to give notice to obligors, whether to perfect the assignment or simply to change the payment instructions. And otherwise, it includes the ability to enforce the receivables directly against the buyer. However, a couple of points to note. This does not mean that issues such as commingling, which we will cover in the next slide, or other practicalities that may arise in enforcement are not present. Additionally, please note that Hong Kong has the concepts of legal assignments, which are where the requirements of statute for the transfer of debt are satisfied, and equitable assignments, which are also enforceable assignments, but are subject to equitable limitations. And Whilst we will discuss arrangements in respect of assignments in more detail shortly, in the context of equitable assignments, which typically arise where notice is not given, from a best practice perspective, to minimize the risk of the buyer querying the action by the finance provider, we recommend the giving of such notices and the conducting of enforcement actions where possible in the name of the seller through a suitable power of attorney drafted to survive the insolvency of the seller. So that's Hong Kong. Angie, please take us through Singapore.
Well, there isn't much to take you through. The position in Singapore is similar to Hong Kong, and we do not think the new legislation will change their analysis. So we can move on to question 7. So, question 7 reads, the proceeds of purchased receivables have been paid into a commingled collection account of the seller. Should I be worried? Well, here comes the favorite lawyer's answer. It depends. For both Singapore and Hong Kong, the ideal position is that collection accounts are segregated accounts and that fixed security can be taken over them in order for the purchaser to control the inflow and outflow of funds. If the security over the account is not commercially achievable, then emphasis should be paid over the control over the proceeds, which can be achieved by a myriad of ways, including requiring the seller to have an account with a purchaser as a collection account into which the proceeds of the receivables are paid, a contractual obligation on the seller to procure proceeds of receivables be deposited into an account designated by the purchaser. In the case of a receivable purchased by way of legal assignment, directing the obligor to discharge its payment obligations by making payments into an account designated by the purchaser, limiting the period of any commingling by introducing regular cash sweeps, and provisions indicating that any proceeds received by the seller are held in trust for the purchaser. The problem that we see in Asia is that the proceeds of receivables are usually paid into commingled accounts which are operating accounts. Be aware of the risks and more if the commingled account is with another bank. You have attended this Mayor Brown webinar, so you have been warned. Turning now to question 8. Ben, would you like to lead off?
Great, thanks Angie. So turning to question 8. Do I need to worry about payments I received prior to the winding up or the insolvency of the seller? And the answer is, well, worry is slightly too strong, and in a true sale structure, you should be fine. However, as we've alluded to, and particularly John talked to in his commentary, under Hong Kong's laws, all transactions, whether or not they relate to supply chain finance or other financings, all transactions are potentially subject to an unwind in the context of insolvency. However, there must be certain bad faith or prohibited behavior or similar arrangements present for such unwind to be ordered. And in this context, we are really talking about transactions where there are gifts or sales for little or no consideration, which may constitute transactions at an undervalue, or transactions that are intended to prefer certain creditors over others, which are unfair preferences. Transactions which cannot readily be sold or determined, which are considered onerous property. Transactions, the payments under which are grossly exorbitant, or they grossly contravene ordinary principles of fair trading, which are extortionate credit transactions, or other transactions that are entered into with the intent to defraud creditors, which constitute fraudulent trading. Now, they are all in the context of pre-existing transactions or transactions before insolvency, but also, and again, as John alluded to, future transactions, dispositions of a company's property after the commencement of winding up without the leave of the court. So these types of transactions may be subject to insolvency unwind. Now, that's the position in Hong Kong. Angie, how about Singapore?
Well, for Singapore, the new legislation did not change the situations in which an insolvency unwind would apply. But it has extended such unwind to apply to companies under judicial management and has amended the time frames which apply. So it will be interesting to see the changes in practice, particularly in light of this extension to companies under judicial management. Back to you, Ben.
Thanks, Angie. Turning to question 9, what if I fail to perfect the transfer of my receivables? And the answer, go and perfect your transfer straight away, because your position is not only subject to certain equities which have accrued, but they will continue to accrue until you give notice and otherwise perfect your transfer. A couple of points to note. Firstly, what does perfection mean in this context? And this is particularly relevant to us in Asia because it's more a US concept. But it effectively means taking all steps and ensuring all necessary publicity to ensure that the interest you hold is effective and enforceable against all parties. In Hong Kong, in the context of sales of receivables, we do not have a registration system. However, we do distinguish between legal assignments and equitable assignments, and this distinction is worth talking about. Firstly, legal assignments occur where the requirements of statute are satisfied, and broadly, this means the assignment must be in writing, it must be absolute. In other words, you must transfer the whole debt and not part of a debt, and the assignment must be executed by the seller, and express notice of the assignment is given to the buyer. And that notice must be given after the receivable is in existence and after it has been assigned. Note that statute only applies to legal choses in action. So an assignment of future receivables will not satisfy these requirements, although it may after they come into existence and the requirements of statute are otherwise satisfied. So for so long as you have an equitable assignment only, for so long as you have not given notice to the buyer, there are various consequences, which include the buyer is able to obtain good discharge by paying the seller directly. Secondly, if the seller subsequently assigns the receivables to someone else, and that third party does not have notice of your interest as finance provider, and they give notice to the buyer first, they may take priority. So that's broadly the position in Hong Kong. Angie, how about Singapore?
Well, Ben, the position is the same in Singapore. And now we get to question 10. The obligor under my payables facility has agreed to pay me directly, unconditionally and irrevocably if I fund any supplier invoices. That's all I need, isn't it? If only life was that easy. It depends on the drafting of the agreement, the regulatory requirements under applicable law, particularly where foreign exchange controls apply, the governing law, and more particularly the mode of dispute resolution, and where the assets of the buyer are. And with the increasing use of platforms, which party actually receives payment and then pays it. The issues that keep me up at night are, can I enforce the agreement against the buyer? What happens if the purchase of receivables is not effectively perfected under all applicable laws? What if the foreign exchange regulations do not permit the payment by the buyer? What if there's a dispute or a credit note? What happens if the receivables have not been acquired free and clear of existing interest? Is there any counterparty risk in payable programs conducted through a third-party platform? What if there is fraud? What if the accounting treatment of the buyer is not as expected? And what is the possible impact on local regulations affecting the buyer? In our experience, there are more variations on payables programs than there are days of the year. Finance providers should carefully review the contractual terms of their program documents to determine exactly who bears what risk in the event of a seller insolvency. And there you have it, another 5 most common questions in respect of insolvency and receivables and payables structures. To provide commentary and reflections on Asian insolvency practice, here's John Marsden.
Angie, thanks very much for that final slide. It is a great segue into what I'm going to talk about now. There are three overarching and interrelated issues that pertain particularly to Asia because of the geographies that we have here. We may have a seller in one jurisdiction, a buyer in another jurisdiction. The receivables themselves may come from a party in a third jurisdiction. The security accounts may be located in a different jurisdiction, and the receivables purchase agreement itself may be governed by another jurisdiction. Thus, in Asia, because of the geographies that are in play, because of the globalization of trade, because of the free flow of trade within the region, many times we're seeing different counterparties across a trade cycle. Will a true sale of receivables owing to the buyer and subject to UK law by a Japanese debtor be able to be collected when a Singapore judicial manager is appointed to the company? The second issue is that companies are not necessarily wound up in their place of incorporation, nor subject to the laws of their place of incorporation. So that means that some fundamental assumptions that were made when taking your agreements and the consequences of a winding up may not necessarily apply. Finally, the company itself may want a forum shop. It may see advantages to the company at the expense of secured creditors, creditors in general, people who have acquired certain assets from the company, of going into one jurisdiction and not another jurisdiction in which to run an insolvency or restructuring procedure. They may want to avail themselves of the Indonesian PKPU procedure, the Singapore judicial management procedure, the Chapter 11 in the US, or go elsewhere. So it really becomes a guessing game about where we're going to be, what laws are going to apply, and how we're going to deal with this very complex interrelationship. And that now brings me to the point that we are at a very important moment presently, because there is so much uncertainty in terms of contractual arrangements, MAC clauses, forbearance arrangements, debtors seeking relief from payment obligations, that it is time to start drilling down on our documents, looking at what they provide, thinking about what route we would do if Armageddon happened. And that is the role, obviously, hopefully, for you to come to Mayer Brown and seek our advice about where you're positioning and how we can help in any way at the present time. On that note, I'll end the Asian section and I'll hand over to our colleagues in the UK.
Thanks very much, John, Angie, and Ben. So as mentioned by Ben, my name is Ravi, Amin, and I'm a senior associate in the Mayer Brown London Banking and Finance team, with a particular focus on receivables and payables financing. And I'm really pleased to be joined by my colleague Sheena Frazer, who's a counsel in our RBI team, as we provide you with an English law perspective to the topics just discussed. And as you'll expect, given the history of the various jurisdictions, there are a lot of similarities. I'll hand over to Sheena at this stage to take us through the first 4 questions.
Thanks, Ravi, and also Ben, Angie, and John. Question 1. Does a company need to be insolvent to file for insolvency? Not necessarily. Under English law, there are also similar insolvency proceedings to those in Hong Kong and Singapore to wind up insolvent and solvent companies. Unlike compulsory liquidation, which is instigated by creditors, a voluntary arrangement is instigated by the company's shareholders. The purpose of a member's voluntary liquidation in England is to enable a solvent company to be wound up without any significant court involvement. It is therefore relatively inexpensive. The directors of the relevant company are required to make a statutory declaration of solvency, following which the company must pass a special resolution to wind up the entity. By contrast, a creditor's voluntary liquidation can be used to wind up an insolvent company without significant court involvement. To commence a creditor's voluntary liquidation, the company shareholders will pass a special resolution that the company cannot, by reason of its liabilities, continue its business and that it is advisable to wind up the company. In both cases, upon the liquidator's appointment, the business ceases, the directors lose control, and the liquidator will collect it and distribute the assets in accordance with the statutory order set out in the English Insolvency Act. Now, question 2. What about involuntary insolvency? In England, there are 3 principal involuntary and formal insolvency processes: compulsory liquidation, provisional liquidation, and administration. It is worth noting that there are also a number of restructuring tools available to distressed companies, such as company voluntary arrangements, scheme, and the new restructuring plan introduced by the Corporate Insolvency and Governance Act. Compulsory liquidation in England is very similar to that in Hong Kong and Singapore. It is a terminal process, the idea being that the liquidator realises the company's assets and distribute the proceeds to creditors in the prescribed manner. We will touch on this later, but the liquidator the business and affairs of the company and can bring claims against directors and third parties to claw back assets and wind transactions. Following the recent Corporate Insolvency and Governance Act, which came into force on 25th June, a creditor cannot present a winding up petition between 1st March and 30th September of this year based on the company's inability to pay its debts, unless the relevant creditor has reasonable grounds for believing COVID-19 has not had a financial effect on the company or the debt issues would have arisen anyway. In England, administration is also a popular insolvency procedure, and at its heart, it's a rescue procedure, and the administrator must act with the objectives of, firstly, rescuing the company as a going concern, and if this is not achievable, secondly, achieving a better result for the company's creditors as a whole, and thirdly, realising property to make a distribution to creditors. There are multiple routes to administration, with the ability to appoint an administrator without the need for an application to the English court. Such out-of-court appointments can be commenced by the directors of the company or a holder of a qualifying floating charge. In certain instances, a court application is desired, and a director, the company itself, creditors, or certain specified officials can make an application to place the company into administration. Upon the administration, the administrators will take control of the business and the directors cease to conduct the day-to-day operations. Now on to question 3. Will I know immediately after a company files for insolvency? In England, you may not become immediately aware of a company's insolvency filing unless you have been in dialogue with the relevant company, or in the case of administration, you are a holder of a qualifying floating charge and have been made aware of the process. In practice, a company's lenders are often contacted at early stages of a company's financial distress and will be aware of any imminent filing. There are a number of ways to find out if a company has entered liquidation or administration. If you suspect a winding up petition, an administration application, or a notice to appoint an administrator has been filed, you are able to undertake a search by telephone using the company's name at the company's court central registry of winding up searches. Such filings are ordinarily recorded on the day they are made. This will reveal that a liquidation or administration may be imminent or that the company has in fact entered an insolvency process. In addition, winding up petitions and winding up searches will be published in the London Gazette. The Insolvency Act requires the publication of winding up petitions, provisional liquidator appointments, and winding up orders in the London Gazette. Winding up petitions must be advertised in the London Gazette not less than 7 business days before the hearing of the petition. Finally, following entry into liquidation or administration, Companies House, the UK's Registrar of Companies, will be informed of the insolvency proceedings. A public search against the company's name or number will reveal the insolvency process and also identify the appointed liquidator administrator. However, it is likely by this time you will have been made aware of the insolvency process through other means, including the press, direct contact with the insolvency office holder, or even the company's own website. Question 4. What's the effect when a company files for insolvency, and why should I care about it? In England, from the presentation of the winding up petition, the company or any creditor may apply to the court to stay or restrain any proceedings against the company. From the making of the winding up order, any proceedings against the company are frozen, except with the leave of the court. The purpose of the stay, and the moratorium in any administration is to prevent any one creditor from gaining priority over others. If permission of the court is sought, a balancing exercise will be carried out considering the interests of the person seeking permission as against the interests of the body of creditors as a whole. Unlike in administration, a company's liquidation does not freeze enforcement of security. However, given the stay on proceedings, a security holder might agree to the liquidator realising the relevant asset to avoid the need for a court application or other unnecessary enforcement expense. Further, any disposition of the company's property after the presentation of the winding up petition is void unless the court orders otherwise. As long as any assignment of receivables is prior to the presentation of the winding up petition, this provision will not bite. In administration, a statutory moratorium is imposed on entry, and an interim moratorium also applies on the filing of a notice of intention to appoint an administrator. The moratorium prevents legal proceedings from being instituted against a company or its property except with the consent of the administrator or leave of the court. Further, no steps can be taken to enforce security, which would include the appointment of a fixed charge receiver without such consent of the administrator or leave of the court. However, the restrictions on enforcement are disapplied in relation to a security financial collateral arrangement, which is the security interest granted by a company over financial collateral, which would include cash in bank accounts and shares, to secure a financial obligation with sufficient possession or control being given to the collateral taker. In the context of receivables purchase arrangements, provided that the purchase is a true sale and not vulnerable to being recharacterized as a secured loan, in a seller's insolvency, the purchaser as the owner of the receivables is able to continue to collect in the debt. For payments of receivables made to the seller's account, it is important to have a trust over the purchased receivables standing to credit of the collection account in order to take the proceeds out of the administration or liquidation estate of the seller. Right, I will now pass over to Ravi to explore in further detail the nature of receivables transactions in the context of insolvency.
Thanks very much, Sheena. So turning to question 5, I have bought my receivables in a true sale and own them outright. Can my sale be challenged in insolvency? In short, yes, although provided that the receivables purchase agreement has been structured and drafted properly, the risk is relatively low. As per Hong Kong and Singapore laws, the two main risks of challenge are recharacterization risk and clawback risk. We will go on to discuss the insolvency clawback risk in further detail later in this webinar, so I'll focus on the recharacterization risk. And just like in Hong Kong and Singapore, to the extent that a sale was recharacterized as a secured loan by a court, in the absence of registration of the receivables purchase agreement at company's house as a security interest, the finance provider would be left as an unsecured creditor in insolvency. Obtaining an outright disposal of receivables of the insolvency estate out of the insolvency estate of the seller is therefore very important. The risk of recharacterization under English law, however, is relatively low if the proper analysis has been taken at the structuring and documentation stage. And the reason for that is because English law is fortunate to have a history of case law which sets out the main analysis required to be undertaken in order to ascertain whether a transaction is an outright disposal of receivables or a secured loan. To summarise in short that case law, the courts have suggested they'd analyse the following. 1, that the transaction is not a sham which disguises the true intention of the parties. 2, that the document is considered as a whole in evaluating whether the transaction is a secured loan or an outright disposal. That the intention of the parties are considered. For example, is it drafted as an outright disposal of receivables? Does the terminology support that by using terms like discount and purchase price, etc.? And finally, ignoring terminology, are the rights and obligations of the parties consistent with a sale? For example, is there an equity or redemption which might suggest that it's a secured loan rather than a sale? And provided that those factors are considered at the time the transaction is structured and documented, and most finance providers will look to obtain a legal opinion from their counsel to opine on that analysis, any attempt by an insolvency practitioner or other third party to challenge the outright disposal analysis is likely to be low. In our experience, insolvency practitioners will rarely challenge a sale analysis unless there's an obvious and apparent flaw in the structure and the documentation. Turning to question 6, can I enforce and collect against the buyer directly that the proceeds are never sent to the seller's collection account. And again, our answer to this question is similar to that in Hong Kong and Singapore, in that, unlike in certain other jurisdictions, there's no automatic stay that prevents collection of receivables because the receivables are the property of the purchaser. The process of enforcement can slightly vary if the purchaser of receivables to the finance provider has an equitable assignment. And an equitable assignment is an assignment that doesn't meet all of the conditions set out in Section 136 of the Law of Property Act, which is required for a legal assignment. So if the assignment is an absolute assignment of wholly ascertainable rights, so it's not a part purchase of a receivable, it's in writing and signed under hand, and if express notice has been given to the buyer, then if all those conditions have been met, it will be a legal assignment. If it doesn't, then it is an equitable assignment. Where the purchaser has an equitable assignment, the purchaser can still collect the receivable from the buyer by notifying it of its claim. And this is the case even if the seller is insolvent. If the assignment is equitable purely because notice hasn't been provided to the buyer, the satisfaction of the final condition of providing notice will mean the purchaser has a legal assignment. If, however, the purchaser has an equitable assignment and any legal proceedings are required to be taken against the buyer for non-payment, the purchaser may have to join the seller as a party to any legal proceedings it takes to enforce the receivable. Now, it's important to note that that's a purely procedural requirement under English law. It therefore shouldn't be seen through a prism of legal assignment good, equitable assignment very bad. If the seller's cooperative, it can simply be added as a party to the proceedings against the buyer. If the seller is uncooperative, it would need to be added as a defendant to the proceedings. In both cases, the rationale is to ensure that the seller is bound by any decision of the court against the buyer. Now, if the seller is insolvent, our experience is that most English insolvency practitioners will be cooperative in being joined to any enforcement proceedings against the buyer, provided that their limited costs in respect of being joined as a party are covered by the purchaser. If, however, the insolvency practitioner is uncooperative, the seller would need to be joined as a defendant to the proceedings, which might require the court's permission if, for example, there's a moratorium against proceedings in place as a consequence of the insolvency process that Sheena described. But it'd be rare for the insolvency practitioner to be uncooperative if its costs are covered, because the practitioner would see it as a procedural requirement for which is unlikely to have any liability. So question 7, the proceeds of purchase receivables have been paid into a commingled collection account of the seller. Should I be worried? And it depends. The ideal position, as mentioned by Angie, would be for the proceeds to be paid into an account of the purchaser or a segregated account of the seller. Where the proceeds are deposited in the commingled general account of the seller, either as a result of commercial pressure, operational ease, or some other reason, the risk increase because it can be difficult identifying the proceeds that represent purchase receivables. After all, cash is fungible. And as a result, there's a greater risk that an insolvency practitioner claims that those proceeds belong to the seller's insolvency estate. To mitigate that risk, there are a number of mechanics that can be put in place. For example, the whole account could be declared on trust for the seller and purchaser for their respective rights, being the right of the purchaser to the proceeds of purchase receivables and the right of the seller to the proceeds in that account that are non-purchase receivable. That trust would be supplemented by the reconciliation process of what constitutes proceeds of purchase and non-purchase receivables being closely monitored and controlled by the purchaser. The bank account would also be controlled by the purchaser through an arrangement with the account bank, so that daily transfers of proceeds of purchase receivables can be made to the purchaser. In an insolvency, therefore, with the proceeds held in trust, such that they fall outside the seller's insolvency estate, the reconciliation closely monitored and controlled, such that the proceeds of receivables can be identified and traced, and the regular transfers ensuring a low balance in the account, the risk and the insolvency practitioner's means of challenge are greatly reduced. In addition, the account could be secured to the extent that trust fails for whatever reason, with the purchaser controlling withdrawals from the account in a manner that achieves a fixed charge over the proceeds in that account. The purchaser can then transfer out the proceeds of purchase receivables on a regular basis and transfer the balance on a case-by-case basis to the seller. In any insolvency, the purchaser would have a first-ranking charge from which it can be paid out. So ultimately, a commingled account isn't fatal provided certain mitigation steps have been taken, of which control of the account containing the proceeds is typically a very important factor. I'll hand over to Sheena at this stage to take us through question 8.
Thanks, Ravi. So question 8, do I need to worry about payments I received prior to the winding up or administration? Possibly. An administrator or liquidator may seek to challenge the receivables purchase arrangement. We have already touched upon post-petition dispositions and a winding up of a company, and in the interest of time, I will focus on transactions at an undervalue and unfair preference. Under the English Insolvency Act, if a company enters into a transaction with a person at an undervalue within 2 years before the onset of administration or liquidation, and the company at that time was unable to pay its debts or became unable to pay its debts as a consequence of the receivables purchase, then the liquidator or administrator can apply to the court for an order to restore the position to what it had been if the company had not entered into the transaction. A transaction is at an undervalue if it constitutes a gift or if the company enters into the transaction for a consideration the value of which in money or money's worth is significantly less than the value of the consideration provided by the company or on terms that provide for the company to receive no consideration. A court will not make an order to unwind the transaction if it is satisfied that the company entered into the transaction in good faith for the purposes of carrying on its business and there was reasonable ground at the time for believing that the transaction would benefit the company. We would expect that the risk of a receivables purchase transaction being deemed to be at an undervalue to be low if, 1, the transaction is structured with a purchase price based on the net invoice amount of the receivables less discount. 2, there are duly recorded board minutes setting out that it was in the best interest of the relevant entity to enter into the transaction, and in making that assessment, the value of the consideration received was appropriate. And 3, if there are accurate solvency confirmations at the time of the transaction, evidencing the company was able to pay its debts and would continue to be able to do so as a result of entering into the receivables purchase agreement. In terms of unfair preference claims, the Insolvency Act provides that where a company at the relevant time places creditors, sureties and guarantors in a better position than the relevant person would have been had that thing not been done, and if in doing so the company was influenced by a desire to prefer, the administrator or liquidator may seek a similar order to restore the position. The relevant time for any unfair preference is 6 months for unconnected parties and 2 years for connected parties before the onset of insolvency. Again, comprehensive board minutes as a contemporaneous record of the decision-making at the time of the transaction combined with solvency confirmations are important. I will now pass it back to Ravi for the next question.
Thanks, Sheena. So question 9, what if I fail to perfect the transfer of my receivables? Ben and Angie have helpfully explained what perfection means in the context of sales analysis in Hong Kong and Singapore, and the position is similar in England. Under English law, as mentioned before, if one of the requirements of Section 136 of the Law of Property Act are not satisfied, the assignment will be an equitable assignment rather than a legal assignment. And we've discussed what that might mean in terms of enforcement against the buyer for non-payment. The other risks are related to the failure to deliver notice and are similar to that for Hong Kong and Singapore, so I'll keep this short. For example, until the buyer is notified of the assignment, the buyer can discharge its debt obligation by paying the seller. It's therefore important to notify the seller on or prior to insolvency, so the buyer has to pay the purchaser to discharge the debt. Similarly, there's a risk that, notwithstanding the assignment of the receivable to the purchaser, if the seller goes on to assign that receivable to another person, and that person notifies the buyer before the purchaser does, that subsequent assignee may take priority in any payment to be made by the buyer in discharge of the debt. Now, representations and covenants in the receivables purchase agreement should prevent that from happening. But if it does occur, and the buyer makes payment to the third party for the debt, the purchaser will be left with an unsecured damages claim for breach of contract in the insolvency of the seller, and potentially a claim in tort against the third party assignee if that third party was aware of the disposal restrictions in the receivables purchase agreement. There are some known risks to note. And so finally, on to question 10. The buyer in my payables facility has agreed to pay me directly, unconditionally, and irrevocably if I fund any supplier invoices. That's all I need, isn't it? And we can only really echo the thoughts of Angie on this question. We'd expect the purchaser to bear the risks of the assignment occurring and the purchase not being perfected, because the buyer will not want to have the risk of double payment. That said, the risks and protections very much depend on the drafting of the underlying agreement between the finance provider and the buyer. With a number of new participants entering this space, and with new investors seeing the potential of payables finance, there have been increases and variations in the way the agreement has been drafted, and they would need to be reviewed in order to properly determine the risk. So that takes us through the 10 questions from an English law perspective. I'll hand back to Ben at this stage, as I understand we have received some questions.
Great. Thanks very much, Sheena and Ravi, for talking to the 10 most common insolvency questions in receivables and payables finance from an English law perspective. We have actually received several questions, but as you can imagine, we are running out of time, so we'll quickly respond to a couple. However, as mentioned, if we don't read out your precise questions, we'll try and get back to you very shortly following this webinar. One question, and the question is about the new UK Corporate Insolvency and Governance Act. What is the impact, if any, in respect to the new company-initiated moratorium? Sheena, that sounds like a UK question. Could you handle that, please?
Of course, thanks, Ben. So the Corporate Insolvency and Governance Act enables the directors of a company to obtain a short moratorium outside of a formal insolvency process in order to provide a breathing space from enforcement action, and that would include enforcement of security by certain types of creditors while they organise their affairs to make the rescue viable. In relation to a true sale receivables purchase, again, like with the other, with an administration moratorium, in the event the seller seeks this form of moratorium, the purchaser, as the owner of the receivables, is able to continue to collect the debt, and the monies on the seller's collection account, which are held on trust, can continue to be paid to the purchaser pursuant to the contractual arrangement.
Great. Thanks, Sheena. Yeah, we've got another one here, and this is a really great question. Question is, are you seeing origination slow down in Asia? Are people still doing deals? Angie, would you like to talk to that?
Sure. Well, that's a really interesting question. What I shall say is, from our observation in Asia, after recovering from the shock of having to deal with lockdowns and work from home arrangements, we have seen more and more deals. I think that this could be partly because of the issues we saw with traditional trade products during the worst of COVID, like when banks had to deal with the challenges of presentation of documents under letters of credit. The fact that there are more platforms here concentrating their efforts in Asia, more and more countries having clearer legislation on open account trades, like the new FX regulations passed in Bangladesh, and the new factoring provisions coming online in China next year, we are seeing more deals. So may that trend continue.
Indeed. Thanks very much, Angie. Well, ladies and gentlemen, thank you so much. That concludes today's webinar. On behalf of Mayor Brown and my colleagues, thank you for your time. We hope you found this webinar useful and that you can join us for our future programs listed. You will all, of course, be receiving individual invites for these future programs. Thank you once again for participating, and ladies and gentlemen, stay safe. Thank you.